A minister of religion, that is
He is reading in English. We can follow directly.
A minister of religion shall be admitted at proper and reasonable times to a prison to visit prisoners.
A religious leader will be allowed to go to prison for appropriate time to visit prisoners, not to inform them about anything. There's no tea drinking. It's to conduct religious or spiritual service. For Muslims every Friday, for Christians every Sunday, and every Christian holiday. All go except this treasonous man who cannot even pray to God. He is prohibited even to pray to God. Regulation 14.3 says 14.2 and is reading in English.
Shall be permitted to hold religious services at such hours and in such places as the officer in charge may permit, and the officer in charge shall make such arrangements for the holding of religious services and for the religious instruction of prisoners, shall not in any way interfere with the routine and administration of the prison.
We, according to the law, we're supposed to be taught religion or religious instruction. In case you don't have a communion, these are things you're supposed to get taught in order to be baptized or participate in the Lord's Supper.
It is the law.
And 14.3 says, and is reading in English, we can follow directly.
And the religious instruction shall be voluntary.
Attending religious service is not mandatory, it's voluntary. I have decided to go, but I've been denied for 68 days. Therefore,
my right of worship
is arguing in English. My right to worship has been gravely violated, my legal right. And I've informed my advocates throughout. They have fought for me so hard, but they have failed. Number 3. Where am I living in the prison? Where am I living exactly? While in prison, Ukonga prison. Honorable Magistrate, Ukonga prison has 2 main parts or sections. There's the first place where all prisoners under prison life term, 30 years term, detainees stay. They're grouped there together. And then there is one place, it's called a special wing, where prisoners under death sentence stay, those that have been convicted. It's those where I am dwelling with those awaiting execution. So he's staying with the death row prisoners.
mheshimiwa,
Therefore, Honorable Magistrate,
ukiwa death row,
if you're on the death row,
manake
what does that mean?
nataka nisomee
Let
sheria.
me read the law for you.
Maana ya kuwa death row.
What does that imply?
Kanuni ya 33
That is Regulation 33.
inazungumzia wale walioko death row.
Talks about those on the death row.
Walioko death row. Inasema hivi,
This is what it reads, and it reads in English.
notwithstanding anything contained in these regulations, a prisoner under sentence of death shall A, be confined apart from other prisoners and shall be under the constant supervision of 2 prison officers by day and by night. Ukikaa death row,
If you're on the death row,
kama navyokaa mimi
as I am,
wakati sijahukumiwa kifo, angalau bado
if I'm convicted of death, at least not yet, probably I will be.
sheria inasema
The law says
wanaokaa death row,
those
wale
on
waliohukumiwa
death
kifo,
row, those convicted and subjected to death penalty, are supposed to be separated from other prisoners,
wafungwa wengine wote.
all other prisoners.
Mimi nimekaa death row
I've been on the death row
tangu Ijumaa Kuu
from Sunday from Friday towards Easter up to this day as we
na
speak today.
nikitoka kwenda kuonana na mawakili wangu
And if I have to go and meet my advocates or my relatives,
nafuatana na askari wawili muda wote.
there are 2 prison officers that go with me,
Kwa waliohukumiwa kifo.
as it is required for those under death row.
Kama walivyo ambao wako under constant surveillance.
I am under constant surveillance
By day and by
by
night.
day and night.
Mimi sio sijahukumiwa kifo,
I'm not convicted of death,
lakini nakaa death row
but I stay on the death row and under constant surveillance
by day.
by day and by night.
Ukiwa death row mheshimiwa,
If you're on the death row, as I have been,
ukiwa death row, pamoja na kuwa death row, bado una haki.
you still have certain rights and entitlements.
Kwa mujibu wa sheria hii,
You have rights according to these regulations. For example,
kwa mfano, habari ya haki
I
ya
talked about the right to worship,
haki ya kuabudu.
or the right to worship.
A prisoner under sentence of death
He's reading directly in English.
to receive visits by a minister of the religious denomination to which the prisoner belongs. For hata wa death row wana haki ya kuabudu. Wote wanakataliwa.
All prisoners, even in death row, are supposed to worship, but they are denied this right, including I personally.
Ukiwa death row,
If you're on the death row,
pamoja na kuwa umehukumiwa kifo,
even when you are convicted of death,
a prisoner under the
a
sentence
prisoner under the sentence of death
shall be allowed such amount of
his wish,
as the commissioner may like that. Wanaruhusiwa kufanya mazoezi.
prisoners on the death row are allowed to exercise.
Kufanya mazoezi. Kwenye chumba changu napokaa mheshimiwa,
Where I am living,
hapo death row. Death row imezungukiwa na mazoezi.
the death row is surrounded by a thick wall.
Kile chumba ya selo inayokaa.
Behind the prison cell where I am, there is a huge stadium, a football stadium,
Kila siku
and all prisoners go there to play football and walk around. For those that are interested, for those that want to run, they do exercises as far as they want, except
walioko death row.
prisoners in the death row.
Wa death row
These cannot go outside the death row walls. They don't have an opportunity to exercise, which the law has said they're permitted to exercise. No, I cannot play football because, as you see, the condition of my legs. But I can walk as a form of exercise. And since I've been on the death row, every day, from Monday to Friday, I just rest on Saturday and Sunday because God rested on the seventh day. So I rest.
From Monday to Friday.
But from Monday to Friday, I walk around the 4 blocks on the death row because there are 4 blocks. No. This area, there are streams of wastewater. The place that I walk around, and these are places where prisoners on death row go to wash their clothes. This is where they go in the morning to rest. For me, I am supposed to negotiate on these streams of wastewater, and one leg is not working properly thanks to unknown assailants that attacked me. I walk every day, and all days I have this fear that what happens if I trip and fall down, because these are streams of dirty water or waste are not for purposes of exercises. For exercises, there's a big playing ground behind these corridors of death rows. But since Good Friday until this day today, 8th day today, I've never been permitted, or anyone else in the death row, to go and exercise, and the law says they are permitted to do that. Therefore, Honorable Magistrate, I have said
the prisoners in the death row. What are the regulations of Prisons Act? Item 58. Item 72, Honorable Magistrate.
Section 72
of the Prisons Act.
A prisoner under the sentence of death shall be confined apart from other prisoners in a special cell or ward, and the treatment.
Okay, he's not speaking English. You can proceed with him.
The treatment of the prisoner under sentence of death shall be as may be prescribed. And
the law, the prison services says, for us who are not in death row inmates, we are not supposed to be mixed with the death row prisoners. So it is now, I have told my advocates for the 6 to 8 days that I've been in the prison, they have tried their best, but they didn't make it. They have failed. Now, Honorable Magistrate, my advocates have told me that I'll come to the court, Honorable Court. My advocates have told me that I've raised these issues before your Honorable Court. They have raised these issues and these violations of the rights of the prisoner, of the detainees. They have drawn your attention on this unlawful treatment of the remand prisoners. And they have told me that the rest that they got, that the court cannot interfere prison services regulations. Now, Honorable Magistrate, this stand, if it is true, if it's what you have told them, is stand violates the law principles of this country.
Completely out of step.
You are completely out of step with the law of the country. Honorable Magistrate,
Visiting justice.
you are visiting justice here. You are one of the people who visit prisons. This law says that in Regulation 48, I'm looking for that section. Kindly be patient with me. The provision is that
a
magistrate
is a visiting justice
of all prisons under his jurisdiction.
You are a visiting justice of
all prisons here in Dar es Salaam, including Ukonga Central Prison. Why do we say that you are visiting justice? That's regard. Because you are an honorable magistrate.
You are a judicial officer.
You are a judicial officer.
I'm a judicial officer.
As a judicial officer, your duty does not end by the time you sentence a person. You have also to continue, even for those who have been condemned to put them into the prisons or to the remand prisons. You continue to supervise their treatment while they are in prison. Now let me take you to the regulations of Mandela Principles.
Principle 4
of the Mandela Principles. It says any form of detention or imprisonment and all measures affecting the human rights of the person and any form of detention or the imprisonment shall be ordered by
or be subject to
effective control by judicial other authorities. And form, yes, Principle 4 of the Mandela Principles. And when the biblical the principle of the Mandela Principles basically the Bible principles of the protection of all persons under any form of detention or imprisonment. Any form of detention or imprisonment and all the measures affecting the human rights of the person under any form of detention or imprisonment shall be ordered by. I can't really follow him. Is he speaking in English? I've said, Honorable Magistrate, this word, other authority, is translated here, and I'm going to give you the proper provision that has translated that. But what is its impression here? It is the court, in my opinion. It refers to the court. It is the court that is supposed to have effective control over prisoners and detainees. So your duty does not end when you said take him or her to the prison. Your duty continues. That's why you visit prisons. And I've been told that recently you have been visiting prisoners as a justice. I've been told that about that, and I've been making follow-up on such issues. Now, Honorable Magistrate, the legal provision here is that it is this honorable court that is supposed to oversee, to control the implementation of the prisoners' rights when they are at Ukonga Central Prison or anywhere else. It is this honorable court not the prison services officer. And I've told my advocates about this problem. They have tried their best, valiantly, they fought hard, but in vain. Now, Honorable Magistrate, there are so many things, but I'm going to summarize. Others, of course, we are going to, when we go to the High Court, we are going to raise them there. But for the things that I've raised here, before your Honorable Court, my advocates, I thank you so much for your hard work. You fought professionally, you did your duty, and you did it professionally. It is time to step aside. And let me do what I should do, I must do.
It is time to let me do what I
Kindly follow him because he's speaking in English.
It is my test again.
Now, Honorable Magistrate, from now on, I'm going to represent myself against the public advocates. Thank you so much for your attention. Microphone, please. We are not getting the voice in the booth. Microphone, please. Therefore, from now on, the arguments are going to be responded to between the public prosecutors on the side of the part of the Republic and the defendant until he says otherwise. So now I request my advocates to come back, but now from now on, the defendant is going to represent himself as he has requested, and his request has been accepted, and the advocates have adhered to his request. Now from now on, it is between the public prosecutors and the defendant himself. Honorable Magistrate, I would like to request another thing, that is aside. May I please get a chair so that I can write, because this chair is too small, because I cannot, of course, sit comfortably here. Okay. The Republic, please, you have the floor. There are so many arguments that have been raised by the defendant, and I hope that you have recorded them accordingly. Honorable, do you see now the communication between my advocates? But please listen. I've already ruled out. I've already provided the. Now you are going to proceed on your own, please. What is the problem here? What is the problem, Honorable Mgwai? Mpoki, what are you saying? What is the problem here? So now, I give instructions. When you are in the court, all the security officers, when you are in the court, Honorable Court, as an advocate, you want to give anything to the defendant, please proceed without any obstruction. If there is an argument, it should be addressed to me directly. But it is not bad to know before you share it, so that there is no any misunderstanding. Noted, Honorable Magistrate.
Prosecution side. Honorable Magistrate, as we directed, his voice is really down. Our contention is, we have heard a lot that the accused has brought before your attention. If we understood him very well, they targeted to inform this court the reason why he does not want advocates to represent him. If we understood him very well, he was giving reasons why he thinks that he should defend himself. Another thing is one of the reasons why of informing your honorable court why he wants to defend himself, even though your honorable court has decided that they have discharged advocates, the defense advocates. We also think it's wise because 110, Section 110 of the Criminal Procedure Act allows the prisoner or the accused person to be represented, but anyone can deny their right to legal representation in lieu of representing themselves. So if the court has agreed that if the accused has denied his right to legal representation, then he has the right, and the court has ruled out that. But if you come to the fundamental issues that he has raised, these are issues that go directly on the prison's services as now he has been treated. And there was no any other issue that here we are supposed to answer or respond to. The issue has been brought on his side, which means the prison's services haven't been heard on the issue. But if I understood him, Honorable Magistrate, I don't think this issue or the issues he raised on how he is being treated in prison, I don't think they came here for your Honorable Court to give a decision or rule on them. If we understood him, but he was giving reasons why he thinks he doesn't want to be represented by his advocates in favor of defending himself. But if there is any other issue where he believes prison services or any officer in the prison services hasn't done what the law says they should do, we say still he has a legal right to pray for prerogative orders, and specifically mandamus. And he says, and he is really a senior advocate, well experienced. He understands what is supposed to be done in order to pray for the reliefs that is requested to a competent court. And these are asked or prayed for. This is Regulation 4. Regulation 4 of Law Reform, Fatal Accidents and Miscellaneous Provisions Act regulations, rules. Law reform, fate accidents in brackets, miscellaneous provisions, judicial review, procedure and fees, 2014. Rule 4 allows or speaks about procedures for judicial review, and also it gives reliefs directly. And if you use this application, that's when now will be given the opportunity for both sides to be heard, and not in the same way, or not in the manner in which your court received information which is one-sided. If laws are present and they've been cited and the prison services haven't received them and he believes they've been violated, then he needs to follow procedures because he's an advocate, rather than requesting for the court to give an order, because it will be giving a mandamus order, and this is not a proper avenue for this application. Implied it's like an application has been brought for prerogative order, but without formal application. Therefore, on the part of the Republic or prosecution, we think it's a trap for us to answer these issues that the prison services is not providing me with these services. I think we'll be entering into a legal trap that will make this court to render orders or give orders that are inappropriate. Prerogative orders are given by special application, as I've informed this honorable court, and there's a special procedure to follow. Where both sides will be given an opportunity to be heard, whether to establish whether what he says is true or not, because he has spoken just orally and we have no idea what is the position of the other side. So I think he should use these specific rules that I've cited, so that your court will be moved to give specific orders where it is established that there is a certain authority that hasn't implemented its legal obligation, so that they're compelled to implement them. But everything is written in the law. Otherwise, after these words, I think we can now move from this and come to the requests of the prosecution. We came here for a mention, as we said. Honorable Magistrate, I think I would like to respond. Are you done? We are going to listen to your prayers later. Honorable, are you done? I am done. On which issue? On the requests from the prisoner, from the accused, about his submission on the treatment he is receiving in prison. Honorable Magistrate, on the allegations that the accused has brought against prison services, I think we should follow the procedure so that the prison services is also given an opportunity to be heard, rather than for this court to just decide on its own without following the legal procedure. I think we are done on our part as state attorneys. Honorable Magistrate, I have heard from the Principal State Attorney. Let me say briefly, Honorable Magistrate, I know the procedure for asking for prerogative order of mandamus. Not that I've forgotten about it, or that I don't know it. I haven't applied for the order of mandamus, not because I don't know it. Honorable Magistrate, I said while I was talking that legally this court retains control, effective control over the detainees or prisoners. I said, Honorable Magistrate, you are a visiting justice, and I said I'm going to tell you the legal provision. And this is 101, Section 101 of the Prison Services Act, subsection 5. He is reading in English, we can follow.
And justices of the peace shall be an ex officio visiting justices of all prisons within their respective areas of jurisdiction.
What I want, I've just informed the visiting justice to do your duty. So you're giving me information, so, and this is not a request. State Attorney, have you understood? This is a report. If this was a request, I would have brought it. But this I've just informed the visiting justice. Therefore, State Attorney, have you understood now? That's what I understood him from the beginning. That he wanted to dispense his legal representation, but he spoke a lot of words. He was wordy. So I was saying, if there is what he was alleging, there was an opportunity, or there is an opportunity for him to make an application. But if it's just a report to the court that when they visit prisons, they'll be able to cross-check these allegations. If it is a report, I think even this court was not supposed to even ask us to respond to it, because it wasn't a prayer. If it's a report or information, we expect the court to say we have received it. Just those. me now say on your submissions, because it's information or report, I've taken them and I'm going to work on them administratively, not judicially. But you're just right. This court has been doing inspection on all prisons in Tanzania and Dar es Salaam, and I, as in charge, I've been visiting prisons. Therefore, I'm going to work on it administratively. Yeah. Now let's go to your main request, Principal State Attorney. Honorable Magistrate in charge, as I said, we are bringing this case for a mention. According to 143 subsection 6 of the Criminal Procedure Act, this case is coming for a mention. With section 245 subsection 6 of the Criminal Procedure Act. After the investigation having directed the orders given under section 245 subsection 5. Therefore, for that reason, we are asking this court to postpone this case until another day or date that will be agreed to inform this court whether the case has been filed at the High Court or not. Are you done? Yes, Honorable Magistrate. Tundu Lisu. Honorable Magistrate, I am thankful for the opportunity again that this case should be dismissed as it is being prayed for. Honorable, if I understood the order of the court, the last order of the court of 2nd June was your Honorable Court will receive information on investigation and the stage at which the investigation is. We were informed on the 2nd of June that investigation is at the final stages of completion. And that they will be informed whether it's completed or not. Now, the Principal State Attorney is asking that we postpone again. The report or information is given is an oral information, no report. Just words from the bar. That is not report or information which is envisaged in law. Honorable Magistrate, the Director of Public Prosecutions. First, let me start with how is the information or report supposed to be, and then I will come back to the provision he has cited, 245 subsection 5 of the Criminal Procedure Act.
wa mashtaka. Hiyo taarifa,
The report
hiyo taarifa ambayo inazungumzwa,
which is spoken of legally, which was supposed to be brought here,
ni taarifa ya upelelezi
is
ambayo
investigation report, which is under this provision.
iko kwenye kifungu cha 16
Section 16, Section 16, subsection 1 and subsection 2
ya sheria ya mamlaka ya uendeshaji wa mashtaka
of National Prosecution Services Act.
16
Section 16,
generally,
but specifically 16.1 and 16.2.
mheshimiwa
Section 16.1
inampa
gives
mamlaka
authority
mkurugenzi wa
to the Director of
mashtaka ya
Public
jinai
Prosecutions
na mawakili wa serikali
and
na
state
wakuu
attorneys
yake
in his office
mamlaka
authority
ya kusimamia upelelezi
to supervise investigation of criminal cases.
mheshimiwa sheria
Honorable
inasema,
Magistrate, the law says,
DPP shall be the head of operations.
he is citing in English,
Coordination of investigations, of criminal investigations. Head of operations. Ndio mkuu
he is the head
wa operesheni
of all the
kwenye
operations
masuala ya uendeshaji
on all issues touching on
wa upelelezi.
investigation of criminal cases.
Na mamlaka ya DPP
And the power of the
ni mamlaka
DPP
ya mawakili wake.
is the power of his state attorneys,
Kwa sababu sheria
because the
inasema
law says
kile ambacho DPP
everything that the Director of Public Prosecutions is supposed to do can be discharged by state attorneys under his office. And if they do or discharge those responsibilities, it will be counted that it's the Director of Public Prosecutions that has discharged a particular obligation.
hiyo section
That is section 16, subsection 1 and 2.
sasa mheshimiwa
Now, Honorable Magistrate, subsection 2 says
DPP
the Director of Public Prosecutions
na by extension
and by extension
mawakili wa serikali
state attorneys
wana mamlaka
have authority
ya kumwamuru
to order
huyo anayepeleleza
the investigations officer
kumwamuru awape taarifa
to direct them to give them report on the stage of investigation.
in the exercise of powers.
He is citing it in
The
English.
director may require any authority mandated with investigative functions to investigate any criminal allegations that have come to the director's knowledge and furnish him with a report on the results of such investigations. And the director shall have power to order that investigation be conducted by an investigative organ event. And
He can even order who should investigate a specific case, but he has authority to order that an investigation report should be submitted to him. That investigation report is what we're expecting to receive here, not just mere and empty words from a principal state attorney. Mere words cannot break a bone. That's a Swahili saying. Now, Honorable Magistrate,
16.3.
Section 16, subsection 3 is what has given state attorneys power.
The director may order that a state attorney coordinate an investigation of a crime, and every investigating officer shall comply with that order.
Therefore, Honorable Magistrate, between the Director of Public Prosecutions that we've never seen here in court and these state attorneys who are here every day when this case is brought, who was the authority of the investigation to order that investigation report should be brought and submitted? It is my submission that it's state attorneys that have that obligation. The Director of Public Prosecutions have never been here. He doesn't have a case file. Those that have a case file, it's the state attorneys who understand what is happening are these state attorneys. They are supposed to give us a report that they received from investigators and bring it before your attention. Not mere words. Not mere words. If they say they don't have, the report, it is with the Director of Public Prosecutions. I am requesting your court to ask the Director of Public Prosecutions to come here and bring it so that they don't deceive the court. So that they don't say it is with the DPP. We want the DPP to come and bring it in person if they don't have it. I believe they have it. Because they're the ones that have the file, they're the ones that have the case all the days. This is the eighth day. If they don't have, then the DPP should come in person so that it brings a convincing report, not mere words. Honorable Magistrate, about Section 245, subsection 5. That is reading it in English.
All that other public officer, after studying
his voice is a little bit far, so I am unable to catch everything. Therefore, you must make reference to section 245, subsection 6. Section 245, 6. This is what it reads, and is reading in English.
After studying the police case file and the statements of the intended witnesses, besides that with evidence available, or the case as such, warrants putting the suspect on trial, or he shall draw up or cause to be drawn up an information in accordance with the law, when signed by him, sent to him under subsection 4, including any document containing the substance of the evidence of any witness who has not made a written statement.
This provision, Honorable Magistrate,
completely premature.
Is mentioned here completely prematurely.
Completely premature.
The order of the court said they should bring formal report on the stage of investigation. That was the order of the court. This provision speaks about investigation that is completed and the files have been brought to the attention of the DPP, and he has read them and he has decided whether we go to court or not. Now wait a little bit. Katuga, can you respond to that point? before I allow him to finish. Is that what you meant on that provision? Honorable Magistrate, what I was saying, the case file has been brought to be read in compliance with section 245. So do you have the case file? That's what the provision means. That's what I was saying. So they have the case file. So what is the stage of the investigation? What did you mean? Honorable Magistrate, what I'm saying, the case, after we have complied with further investigation, that is section 245, subsection 5, it has been now brought to be read in preparation of taking the accused to the High Court. That's what this provision is supposed to say. Now, I don't understand where exactly am I not being understood. Tundu Lisu, have you understood? I've understood him. And that's why I've said he has brought a cart before the horse. He was supposed to understand, to comply with the order of the court. One, Honorable Magistrate, you gave an order that they should bring a report, that I've said that they should bring a report. What is the stage of investigation? Honorable Magistrate, that we have completed investigation and this is the report. And then second, then he has to say, because investigation is completed, Honorable Magistrate, we have now taken the Director of Public Prosecutions as received witness statements and the case file, and now he is reading the case file to decide whether to prosecute or not to prosecute. Wait a little bit. Is it correct what the accused person is saying? About what? You have understood him. Fundamentally, you're speaking one language, but this is interpretation. The accused person that has elaborated to the court is a 22-year-old experienced advocate that has tried to say how is the submission supposed to be done smoothly in order to inform the court. How have you implemented its order? That's what he was saying. So I was expecting you to answer what he said. Is it right or improper for me to record? I think he's supposed to say and then we answer. It's okay. Now, Honorable Magistrate,
mbili 44 DPP anapelekewa witness statements.
Unajua,
Ndio.
Mimi nataka to save time.
Yes.
Nataka to save court's time.
Yes.
Ulioyasema ni sahihi kabisa na ambayo aliyasema. Isipokuwa yeye tu alisema kwa kifupi. Basi. Kwa hiyo ili kupunguza kuongea sana. Kwa sababu ulivyosema ndivyo ambavyo amesema. Ila yeye aliongea kwa kifupi na kurifaya ile amri ya mahakama ya kwanza. Kwa hiyo ninamtaka tu arejee aseme nini ambacho kwa maana ya upelelezi umefikiwa. Kama ni hayo ambayo umeyasema, then huna sababu ya kuendelea kucite hivyo vifungu vya kisheria ili tuweze kutunza muda wa mahakama.
Kwa hiyo kama angalau umepeleza vizuri mheshimiwa. Kwa hiyo upelelezi umekamilika. Faili liko kwa DPP analisoma.
Katuga ni sahihi au sio sahihi?
Mheshimiwa, ni nadhani sijui hatuelewani. Yaani iko hivi.
Ndio.
Jalada lilirudishwa kwa further.
Yes.
Time ndio ilikuwa taarifa hiyo.
Ndio.
Ile further investigation imefanyika. Jalada limeletwa kwa DPP kwa ajili ya kusomwa, kuamuliwa kwenda mahakama kuu. Ndio kauli niliyoitumia.
Okay, sawa.
Sasa yeye
ni sahihi, ni sahihi. Yeah.
Mpaka tutakapofaili mahakama kuu ndio tunaiambia mahakama imeshakamilika tayari, nyaraka iko mahakama kuu.
Ni sahihi.
Ndio mheshimiwa, lakini ukisema nilazimike kusema hayo, mimi nasema kwa mujibu wa vifungu.
Yeah.
Kama nilichokuwa nasema sasa, yeye anataka hatua hiyo, anasema sasa hivi linasomwa ili kuamuliwa. Tukishaamua ndio tunakuja kuiambia mahakama umekamilika na tumefaili mahakama kuu. Hivyo ndio sheria.
Yeah, ni sahihi. Ni sahihi.
Asante.
Mnajua mnaongea lugha moja?
Nimeshakubali.
Yeah, sawa.
Nimeshakubali.
Okay.
Tumwachie DPP Mwakitalu asome jalada na kutana ili tuje tuambiwe baada ya kulisoma ameamua nini. I hope kusiwe tena na dana ya ahirishwa.
Mheshimiwa, ndio hayo sio nasema sasa.
Ndio maana nimesema mnaongea lugha moja.
Sawa, ni sawa.
Mnaongea lugha moja.
Hiyo ni sawa sawa. Kama tumefika hapo, jalada limekwenda, linasomwa, tukutane baada ya wiki mbili kama.
Yeah. Siku 14 zinaangukia tarehe 30, lakini shauri lije tarehe 1. Sheria inaruhusu ndani ya siku 15. Kwa hiyo tarehe 1 Julai.
Sawa.
Imekaa sawa?
Asante mheshimiwa.
Sawa.
Okay.
Kwa hiyo ninaahirisha shauri hili mpaka tarehe 1 ya mwezi wa 7 saa 3 asubuhi. Asante.